My lord, and after notice matter, against the dismissal order, I have filed. My lord, a divorce proceeding.
Move it Monday. Monday you file the payment. Today you will possibly the pattern of mistake. That's what my move the memo on Monday. Yes, move. But on list files. For obvious reasons.
Item 40.
Accurate.
If not access or taken up to urgency will the appellant is the white and expert decree. That is called for condonation of delay below. If not, it is kindly taken up below. Item 44.
44.
Item 40.
40.
My lord.
Please wait.
Yes.
We'll try to take.
Yes.
But may I mention item 62 that admission of that handicapped sector education.
I admission matters. Another was of
63 minor, 63 and 64. 63 and 64 minor. Can you take it up
when you from your other side?
My senior is
ESBI office. Lordship may take it up immediately after.
2 p.m. And
your matter, Mr. Rao?
63 and 64.
When time?
61. 2:30.
Shanti is there.
I have in that case, a group of case I have sought for inspection. I want to dispose of the matters so that for consideration. So I am expecting a letter from them. So this can be disposed of all the matters.
Today at 2 p.m.
Today,
No, it's a student's matter. We have seen what the apex court
authorized because there is a judgment of the last year's court. By virtue of that, only some addition can be done. Is to
at 2 o'clock.
I will give the judgment.
You try to get that instruction.
Yes, sir.
Right now.
I'm trying to get you.
Yes. 64.
63 and 64.
63, 64, and 40.
62 minutes.
62.
Item 61 as well.
61 also. 61, 62, 63.
61, 63, 64.
Similar.
These 3 matters.
3 matters similar.
At 2 p.m. Around 2 p.m. just 5 minutes. This side, that side. Maybe.
I will get this.
The instruction task.
Item 7.
Please wait.
In those matters.
Mention.
In the very same matters.
Page mention.
In 10 we are not.
Item 45. One matter, item 49. And IA is pending for last week for us. So that it can be.
49.
Item 49. I am filing IA is pending. Let matter. Yes.
I may pardon, Lord. Not yesterday list your lordships already had a judgment reserved, Lord. Then I am just giving another judgment letter. Letter judgment.
Yes. Page 2 upon I mentioned that is page 3 19 to 22.
22, page 4, 23 to 29, page 5, 30, 31, page 6, 30 to 34.
Item 34 will be. When a contract counsel, Mr. Bahani is on accommodation, let it come next.
State 34. Yes. They're seeking adjournment. Adjournment. In August 25th of August. Third week of August. Who's Yes, ma'am. Third week of August. Article Commerce.
Yes.
36.
36.
37 to 42.
Item 36.
36 is what you want, madam?
The appellant is coming from culture, so there is late.
There are 10:30.
After 2.
Kali 10:30. Particular appellant 10:30.
Madam, can you wait till 2 p.m.? Can you please wait till 2 p.m.? 36.
Page 8, 37 to 40. Page 9, 43 to 47.
Item 53 permitted.
English.
42. At page 10, 48 to 52.
49. I was mentioning 49. I have filed an IA. In view of the recent cases, the government sector bill, it will dispose of that IA may be listed restrict for Oros, my lord. So that it yes, my lord. I have copied it. Copy I have solved. But today it may not reach, my lord. After lunch I have some problem. After lunch I will not resolve it. Yes. Yes.
I have a button, my lord. Item 50.
After 2 p.m. 2 p.m. I will intimate. No, more no hands, but I will intimate.
2 p.m. I will not.
Before that. Before rising. 49.
50, my lord. Item 50. This is a matter, my lord. The matter remanded by the Honorable Supreme Court for adjudication of the press hearing, wherein appellant Mr. Sharma is appearing. I have talked to him yesterday, my lord, right? I have filed a counter affidavit on behalf of the respondent 124. I want a lordship. My counter may be taken up along with the next week. Okay. No, my lord. No, my lord. My lord, evening, I request your lordship next. There is a direction for since April, my lord. My lord. Yes, my lord.
There's a personal appearance. There's before rising, because at 1:30 I have to leave. I have to go to Calcutta. My father-in-law is not well. He's admitted in hospital. I have to go.
My lord, that item 50, my counter will be kept on record, my lord. I have filed it. Unless, my lord, since I have filed first week of registration.
11, page 11, 53 to 56.
Problem.
Item 53, my lord. I am for the appellant. I am permitted to withdraw. Yes, ma'am. It is section 9 application.
There's some implication. Yesterday, actually,
Actually, 54 to 56. 6. Page 11, 57 to 60.
57, man. Yes, take up any next man. In any matter. 58. Respondent, my lord. I also, yes.
I 58, my lord. And 2 weeks after, my lord, I appeared in this case, my lord, pursuant by lord's direction. Yes. 2 weeks after 25th of August, my lord.
My lord, here, my lord, one IA has been filed. Because Orissa government has been changed, the designation has been changed to Orissa Gramin Bank. I have already filed that under orders. That day, listing, it should be listed under orders. That is my prayer.
By the appellants. That will be placed.
Copies of my lord.
I am sorry.
Page 15, 65 to 56.
After adjustment of time. After adjustment of list, I have to
Under 63, 2 p.m. it has been fixed.
54 जाएंगे. Page 15, 65, 66. Page 15, 57, 68.
Item 10, ma'am. 10. I am for the respondent.
You're also take it that next week so that I will take instruction whether there are.
The referring petition is not the problem of the week. This is an initiative of the super.
But I am for the respondent, my lord, but the appellant is.
Item 1.
My lord,
Yes.
here the background of the case is the petitioner has
Poultry farm.
poultry farmer. He took a loan from the bank during the year 2014. He is a poor lady, my lord. She started running a farm, poultry farm. Thereafter, she continued it till 17 for 3 years smoothly. Thereafter, some allegation was made by some of the 1-2% of the villagers.
So poultry farm was removed.
Yes, you shifted to somewhere else.
Pollution.
Yes, sir. However, my lord,
Required, sir.
my lord,
Poultry farms
My lord, I am-
pollution.
Yes,
FCTV,
yes.
pollution.
Then, my lord, however, I came to this honorable court, my lord. Tahsildar directed for eviction. Eviction was stayed. Ultimately, the writ application was disposed of. The lordship may kindly see order that
What it say? What it say?
page 20.
What it say? We believe you.
Expert committee was directed. They go and see
To the matter.
whether it will be shifted or not. Then, my lord, expert committee gave a report in my favor.
Not to shift.
My lord, pursuant to the direction, my lord,
Compliance of CPCB and SPCB norms. You are compliant.
my lord, for that reason, your lordship may kindly see the expert report.
The question is for then what is the difficulty for you?
No, again, what happened, my lord? My poultry farm was running, however, when thereafter they came to this honorable court. Know how they have started again because after report in my favor,
PA.
no, but they challenged it in a writ application, my lord.
Who challenged it?
My
The
lord,
same person who had put.
Yes, the whole complaint filed, my lord. Then it
Subject matter was of a single judge.
My lord.
single judge.
Even private.
Yes.
However, my lord, honorable single judge at the time of hearing directed said, no, Mr. Tripathi, you deposit 10,000 rupees, a lawyer will go from this honorable court, he will give a report.
How that lawyer will examine all that?
My lord,
His
my
expertise.
is this. Now, expert committee consisting 4 persons, they are all doctors.
One second. Whether about the membership, there was any objection from the complainant? You have constituted a committee comprising of A, B, C, D. They are not competent, no, or they are otherwise biased in favor of him. Therefore, remove X, remove Y, remove Z. Was it your case?
No.
No. Just you went and challenged the.
No, my lords. In view of the direction of this honorable court, when application was filed, it has given that a committee will be constituted and they will give opportunity to the opposite party here and the petitioner. Notice was issued. We also present, my lord, including the petitioner, well, present, my lord. Inquiry report was submitted indicating therein that the farm is situated with the 15 meter distance to the residence of the present opposite party. Our objection that a farm is continuing inside the village, it was categorically stated in the report that the farm, the inhabitants, the villagers, it has learned there are residence building for human habitation before the commencement of construction of the polluting sea. Nearest residence household is situated about 30 meters on south, each side 15 meters on the north side. So this was the report of the inquiry of authority, my lord.
Committee.
Committee. In spite of that,
committee said, since your farm is within 5,000 category bird, no condition is required by as per the guideline. The page 23, my lord. Sorry, ma'am.
They should be false because we have to assess your submission. Each sentence we have to weigh.
My lord.
Can it be true? Cannot be true? Like this, na? So committee says if poultry population is less than 5,000, then no conditions are applicable. Is it true or not?
Well, the poultry farm is below 5,000, my lord.
Then no.
According to the guideline,
The guideline.
My lord, I will read one paragraph. Yes, guideline.
My lord.
Report in your favor is saying.
My lord. My lord, my lord, why 4 doctors, not 1 or 2? 4 doctors. Your lordship may kindly come to page 23.
SPCB dictate on that.
Yes, yes. Page 23, one paragraph I will read. The expert committee report. Therefore, read appeal, my lord. Page 23, read appeal. This is the report of the committee directed by this honorable court, my lord. Therefore, in the above backdrop, as per the prevailing CPCB and SPCB guidelines, my lord.
Page 22.
My lord.
Report of the inspection team for inspection of
DBO Bhubaneswar, BBO Balipatana, ABS Balipatana, with as a team.
So, why is the SPC?
My lord, they have followed. They have written in their report.
Instead of this, that concern authority.
And they may end up in saying that not report.
Yes, yes, yes. But my lord, 2-3 lines I want to read. I have. My lord, 2 lines more I want to read, my lord. So, and SPCB guidelines and honorable NGT rulings.
Again, it becomes one person, one social. The committee comprises of 4 persons.
My lord.
All right.
4 doctors.
4 doctors. Now, as my esteemed brother suggested, we will have a member from the State Pollution Control Board and 1 member from the Central Pollution Control Board. 1 member from the Civic Society, which you will choose. Both of you choose. Otherwise, it will be 6. If they are divided, resolution will not happen. If they are 7, therefore always benches comprises of uneven numbers.
We will leave it to your lordship. Please.
What is it? Agreeable.
Only our objection with regard to that farm is continuing within inside the village.
No, it will continue. Do not worry. Let the report come. Then rest of the things, all other exercise would be done by the concerned.
These poultry farms are encouraged and they are subsidized, given money.
Only direction was
that is needed for people.
We are not opposing. There are 2 farms. 2 farms are there. One was directed to shift. One has already been shifted. So only direction.
But their poultry number is what? Above 5,000.
Both in same category.
Above 5,000.
Those are same category.
No, we are asking. What is the number?
Less than 5,000, my lord?
Less than 4,000. That is less than. I have kept, my lord.
He's insane.
But only for direction of shifting, my lord. That was given the honest. I am so far as this report, I am not disputing to do. Para 15.
Apart from there, only the suggestions will be retained, will be looked into by the new committee, and it will form its own report. On the basis of the report, concerned authority will be engaged. With this understanding, Madam please.
Yes, ma'am. And by considering para clause 11, 12, 30. But
If there are other than these members.
other than
Yes, independent.
and considering the distance.
How distance from? All parameters. All parameters. I am not expert.
So 4,000 ଅଛି ବୋଲି ଘର ଭିତରେ କରିବେ.
No. Even if advocate commission report is, I have less than 4,000.
Now be patient with that.
Now we will give dictation. My lord, just listen. Yes, my lord. If you have any suggestion, we will modify our order.
My lord.
Kindly be seated. My lord. Appellant, a poultry runner, is knocking at the doors of appellate court for laying a challenge to a learned single judge's order dated so and so, whereby the writ petition number so and so filed by the private respondent having been favored. What is that direction?
To shift the farm.
Where favored, a direction has been issued to shift the poultry farm, presumably for abating the private or public nuisance. First. Next paragraph. You are after notice you have come or caveat you have entered?
Caveat.
Respondent having entered caveat through his counsel opposed the appeal, contending that the order of the learned single judge is unassailable in terms of facts and law as well. First off. Next paragraph. We heard the matter for some time, and the members of the bar stood tall in accepting our suggestion that a new committee comprising of the existing boards by designation and designation, along with one member from the State Pollution Control Board and another from the Central Pollution Control Board and yet another from the civil society, be formed to look into the matter afresh in terms of suggestions and scripted and para 15 of the earlier committee and take a decision in the matter, make a report in the matter to the jurisdictional authority, which in turn will take the decision on the said report after hearing all the stakeholders, including the parties before this court. All right. This entire exercise has to be accomplished within a period of 3 months. All right. First, that happens, the poultry business shall continue as usually, subject to compliance, strict compliance with all normative procedures. First, next paragraph. ordered accordingly, and writ abolished. Who should appoint the civil service member of the civil society? You suggest some member of the party will appoint him.
CPCP, Central Pollution Control Board.
So there will be competition. It's difficult. Suppose political affiliations start.
Yes. Vegetarian or non-vegetarian.
Which party?
CDBO and Tahsildar is there.
Whether the poultry, though not making it, the Sikhs are of this community or that community. Like this it begins. Yes.
CDBO and Tahsildar is there.
Video, block developed officer of that locality.
Video can be.
Independent officer, na?
Tahsildar.
Yeah.
Instead of civil society member, one with the jurisdictional Tahsildar of the taluka. Or the taluka see?
No, Tahsil.
Tahsil.
Is OP number 4 already is in the
OP number 4. Okay. All right.
The copy to
A copy. Registry shall send a copy of this order to
the Central Pollution Control Board, Regional Office, Bhubaneswar, and State Pollution Control Board, Head Office, Bhubaneswar.
for
and also to Tahsildar.
Information and compliance. Tahsildar is a party. He is the fourth respondent.
For the response.
Parties will access to production.
We will sign it today only. Because time may be taken. All right. Then it's better. Parties may act upon. Parties to act upon. Parties and all others to act upon.
On production of the website copy of this order.
Website copy of this order.
Officer have the liberty to produce the copy before the authorities.
Yes.
Item 20, may I please continue? Here, my lord, the case of the
One passed over matter, this baby has come, and Mr. Pusti.
My apology.
We are referring to that to mediation. Mr. Pusti, which matter?
Item number 9.
9.
Why for everything apology?
The case of the matter appellant before the Honorable Single Judge, that the writ petitioners were appointed as a Group D employees, my lord.
Group D.
Group D, my lord. While they are continuing, a rule was formulated in 2019, giving 10% promotion from Group D to Group C post, my lord.
That rule was made in 2019.
8th of March 2019, my lord. 10% was given for promotion from Group D to Group C. Subsequent
90% will directly from the market.
From the open market. The government in 2023, my lord, enhanced that 10% to 20% promotion on the ground that since sufficient persons are not getting promotions, 10% enhanced to 20%, my lord. A gradation list was prepared. In petitioners, all petitioners before the writ petitioners, name are found place in the gradation list, my lord. Only condition that they have to call for the qualifications are to verified, and they are called for the skill test, which is qualifying in nature, and they have to give promotion that out of 20%, my lord. 234 were advertised.
234.
So 46 posts remain for promotion, and the rest are to be direct recruitment, my lord.
Yeah. Total cadre structure. No, it's about advertised vacancy. That percentage is always cadre.
The 10% of not advertised. 10% of the vacancy, my lord. The what is 10% of the vacancy?
So that is how
vacancy.
That became 20% of the vacancy.
Subsequently announced to 20% of the vacancy.
Not the cadre state.
No, my lord. No, my lord.
Then of course, already promotees are there 15%. Please appreciate this also. Assume a situation. This is how this broad principle say which decision percentage.
My case is
please appreciate this because that's a basic fact. That's the basic fact.
But then the rule.
That judgment of Supreme Court where it says that cadre has to be taken, that is the principle applicable to this kind of reservation also.
But for a moment, can you see the rule, my lord? It says
Rule you have very clearly said that vacancy.
it says, my
Vacancy
lord,
corresponds to the each category. Because what is the decision? 1 and 2, Surajban Meena, 1 and 2, whatever. Why they implemented? Because then it gets distorted. Suppose already out of 100 posts, 50 are there promotees.
my lord.
Rest 50 is advertised.
My lord.
If let's see.
The person which advertise out of that 50 posts.
So kindly, you are not, you have the hard question. How can
Sorry,
you-
madam. Sorry, madam.
50 are there of promoted category.
Madam.
Now 50 is a hypothesis.
Madam.
Hypothetical situation there.
Madam.
50 is advertised.
Madam.
According to you, another 20, that means are of them which are to be directly proved.
Enter cadre strength, my lord.
Yes. And that is the principle of 80-point or 100-point roster also.
It's a principle of DRPR, PRDR. One of the principles. But this I did not know. Anyway, just look into it. I will also look into it.
Madam.
All right.
Madam.
Call the week after next at the request of the counsel, arguing counsel for the appellant.
Item 21.
This subject.
Then this matter is one of the identical matter which stands on the same footing of the other matters 63 and 64 Miller. That is nursing matter. Taken together. I have already. Yes, Miller. It will take 5 minutes. I have already intimated my respected senior Mr. Mahanti also. It will be taken up together. Miller?
Instructions.
Miller. It may be taken up along with that matter. Obliging.
Item 22.
I had the previous occasion to argue before your lordship regarding the deductions being done. But here, the person, both the petitioner and the employees of this, they were given certain remuneration for doing the arduous job after the port hours. Thereafter, my lord, by virtue of yes, my lord. It is, my lord.
That I have also annexed in page 16.
But only difference is, my lord, in that case, your lordship set aside that order in respect of the petitioner. Their deduction was not that because I had got a stay from this honorable court. That is the only difference. The rest
Status is also different. They are the court masters, these are the peons. No, that is the status. In Rafiq Masih.
Yes.
CP Unial and Rafiq Masih did.
Matter of this is substantially similar to the one being decided in the meeting number
6209 of 25, disposed of on 26.
Yes,
that's a registered judicial High Court of Orissa and another. Page 16. 25, 26, 625.
Not page 16.
The granted plea remote employee who had put in the work after the work
Usual first time. Next paragraph. Learned counsel appearing for the appellant submits, and we agree that like cases should be decided alike as a normative principle of adjudication in the absence of differentials. First of all, learned AGA Mr. Mohanty with the usual vehemence submits. In the coordinate case, the employee belonged to the cadre of courtmaster, whereas in the appeal at hands,
Peons.
the employee happens to be the peon. First of all, that does not make any difference to the principle on which the coordinate decision was read. It has been read. First of all, in fact, the decision of the apex court in Rafiq Masi, 2015, 14-15, 2015. 15. Give that citation. Comes to the aid of the appellant, the petitioners, aid of the petitioner. Rafiq Masi. Petitioner. First of all. Next paragraph. Learned counsel appearing for the petitioner brings to our notice that in the coordinate case, there was interim order restraining recovery, and in this case, there is no such order, and recovery has already been effected. And therefore, there has to be a direction for reimbursement of the same. First, this is absolutely reasonable. Next paragraph. In the above circumstances, this petition succeeds. What is to be questioned?
Annexure 2.
The impugned order dated 30/11/2024, to the extent it concerns the petitioner herein.
Petitioner here is the serial number 6.
Namely,
Basanta Kumar Pradhan.
Pradhan. And stands quest. First of all, coupled direction, coupled with a direction to the respondent. To whom?
Registered.
To the respondent.
Respondent number 1.
First respondent to refund.
Respondent number 2.
Respondent number 2.
Order has been passed by
Special officer.
Special officer.
To refund whatever amount that has been recovered.
That has been quantified.
That is,
it is 31,446.
31,446 within 4 weeks. Failing which, the amount will carry interest at the rate of 1% per month, which may be recovered from the hearing officials.
The second sub item,
yes,
is name is only changed and the amount will be 18,750.
18,750.
Status is also same.
Status is same.
Status is same. So it's the same.
The amounts are different.
See that citation.
2015 AC.
Yeah,
696.
Our steno Samal knows, but still we are asking you.
2015 AC is 696.
Yeah. Yes, this is citation. Reluctantly made easy. Okay.
Well, one thing I was sitting here, and if your lordship permits, should I say,
yes,
that mediation which the Honorable Apex Court said, and it's very good that your lordships are also sending her. But one thing, my lord, I'll just, if your lordship permits, it came to my mind as an officer of the court, and
the idea.
your lordship in appeal against the order of the London single judge, where it was directed to consider the case of the petitioner in the light of the old rule. And in the meantime, the amended rule has come, rehabilitation assistance rule. Your lordship have formulated. Yes, that order. Yeah, I have shown to my learned friend and he's agreed. Yes, amended, your lordship have formulated that order.
Other day also that Honorable Apex Court judgment also.
Yes, Honorable Apex Court judgment.
Jita Luha. Luha.
No.
We have given that copy also, Jita Luha.
Jita Luha also referred by Justice Sahoo, my Lord Justice Sahoo. That copy.
That I will provide it.
Yes. And your lordship's judgment. Your lordship. That I will provide. Yeah, I will give the record.
That is civil appeal 5842 of 25.
No.
They are saying that already this court has passed.
Even prior to that.
Referring to that. Prior to that one.
That is either a writ petition, if it is judicial position, or a
Writ petition. Already.
Same order has to pass, your lordship's order.
See, I can refer no.
yes.
25, my lord. I have entered appearance, my lord. Last occasion, I have taken the copy of the limitation petition. Today, I have taken the soft copy of the writ appeal. I'm for the respondent, my lord. And I seek 2 weeks' time to file my.
2 weeks.
Date would be some date would be.
My lord, date may be fixed. 11th.
Okay, difficult. All right. Yes, 2 weeks up. 2 weeks up.
Item
26, my lord. Some defects are there. I will rectify. That notice was because I am the wife. In the judgment, husband agreed to maintain the divorcee wife. It's not maintaining, not only the wife, also one child is there, boy is there, son is there. My lord, sir. No, notice taken. Let notice goes. That order, lordship may remember that. That was not, my lord's order has not been complied. That judgment has not been complied with by the husband. That whole difficulty. He agreed to maintain his child and myself and the wife also. That was the judgment. Yes.
How can that be a ground for revocation of the?
Not leave. Yes. That is in our favor. If my lord will, yesterday I have talked to the counsel who was appealing this case. He said that I will talk to the Poultry government. Yes. Yes. Yeah, Hajur do nahi to sit fees. School fees is not paying up the child. Now, my lord,
we are only telling you, order is in your favor.
Yes, that's true.
You want to vacate that order?
No.
How that will help you? On the other hand, enforcement of the order.
Implementation of that order.
Therefore,
yes,
you make a memo saying that I do not want recall review of this order.
Implementation.
Only its implementation.
Yes,
Therefore, kindly implement that.
Yes, madam.
You make that.
Yes.
To the husband.
Yes, madam.
That helps. Learned counsel appearing for the review petitioner, who happens to be the wife, submits that by mistake review petition has been filed. Instead of seeking implementation of the said order, which is in her favor. First, he also requests us to treat this review petition as an application for enforcement of the judgment order. First off, since we are exercising family court jurisdiction and we have parent patria jurisdiction as well, comma, in the special circumstances of this case, the request of the counsel acceded to treat this petition for the enforcement as the one for the enforcement of our order, correct?
Well,
Our orders.
yes, my lord.
Order of
This alone
the order of the coordinate.
Tribunal bench.
Of which one of us?
Which one of us was a member? Into bracket, Honorable. First, we can issue police notice by way of emergent notice to the respondent husband, returnable within 2 weeks. You just file a memo saying that it's for implementation.
Item 27.
My lord, in the state appeal, where the impugned order has already been struck down in a writ appeal, and this matter has been covered earlier. Yesterday also I was that a Rai case where 32 revisions, para 6, 32 revision has been allowed by this honorable court.
This is
Honorable,
Fresh matter notice has to.
perhaps.
Notice.
Similar matter, survey settlement.
Yes, notice is to go.
Notice. Issue emergent. Yes.
Yesterday's item?
Do you have that number? We'll say that we call this matter along with that. So that by one order, 2 matters will go.
And they will not have to type it again also.
That's
Just
what.
simply reproduce that order.
How this can be done?
This is the thing. Call this matter along with the WP number.
Item 28.
Can I take back that judgment to the?
Yes.
Yes, Mr. President.
Yes, my lord. My lord, in this matter, my lord, when the posts have been abolished, the clear stand of the state was the posts have been abolished. The Lord Single Judge still has given the judgment that should be absorbed, they should be regularized.
How many years of service he has put in?
But glance to the impugned judgment para, I am referring. Our contention has been recorded at internal page 10 and the running page 100, where we have taken the clear stand. Para 11 and 12 also may kind of have a glance.
That post is abolished.
Yes.
What do you say? Apex court said once post is abolished, no rights will accrue.
A copy not sir, survey copy man.
Copy. Read appeal.
Read appeal copy.
Notice has not yet been issued.
They have appealed, I think.
No.
You appealed before the writ court.
You accept notice for the respondent.
They have appeared, therefore I was arguing. In fact, if they want a copy, I will serve a copy.
Already notice was issued. Not admitted. No?
Notice issued.
Fresh matter.
Yes.
Issue emergent notice. First off, but you're taking usual steps. Learned DG, the appellants shall serve a copy of the appeal papers on the counsel who represented the respondent before the learned single judge. First off, interim order as prayed for. They have appeared on their own. Formal note. Yes. Apex court said once post is abolished, where to observe? That's what. At least there are some exceptions. Look into that. Okay. Interim order as prayed for till next date of hearing. Call after 8 weeks. Okay.
Item 29.
Yes, sister.
Your Lordship, item 29, I am filing my Vakalat number today on behalf of respondent. Your Lordship, and I seek some time to file counter also because I have received the readable copy, Your Lordship, last week.
To appeal also you will file counter.
Yes, I will
You have
file.
not filed objections in the before the writ court.
Your Lordship, I got the Last time got the instruction, I will be filing.
Whether objections were filed, you appear for whom?
For the petition.
For the appellant. Whether any objection statement was filed, the counter was filed. Why do you sit in the court hall idle? Why can't you turn the pages of your case papers? Your client will be happy that my lawyer is reading my papers. Clients should be very wise nowadays. They will be seeing online proceedings. They will see what his lawyer is doing, whether he is reading or not. How if you turn, this is called in Sanskrit, Yuddha Kale Shastrabhyase. At the time of war, you are going to prepare. It's not so difficult.
When the war is not connecting the arrows.
No, that's fine. Call this matter after no counsel enable counsel for the appellate to come with more preparation. It's not an issue.
Notice was issued, my lord.
Madam is appearing.
Yes, ma'am.
You appear for the employee.
Yes, your lordship.
Madam so-and-so appears for the respondent employee and seeks a short accommodation to have instructions. We'll say have instructions, not object.
Yes, your lordship.
First one, call this matter after 3 weeks.
My lord, interim order.
Mr. Mahanti.
No, my lord. I am on behalf of Jagjivan Pradhan, my lord.
So,
S.R. Behera, my lord.
so S.R. Behera on behalf of J. Pradhan, appellate.
Interim order.
Had you argued, you would have given interim order.
There is
You have not argued at all.
there is an interim order, my lord. On the last
No. Interim order dated
7/2025.
Continue till next date of hearing. Always in the court hall, one should not chit chat. This is what our seniors used to say. Don't waste your time. Invest your time. Read some law book. Read some papers. That always helps you. Have you ever seen anybody committing suicide because he read more? No. Is it that? I can.
You have filed your appeal now and record.
Yes, your lordship.
Name of the lawyer, counsel for the response shall be indicated in the corpus shall be given.
Yes, take that. The local factory.
Yes, I have not.
No, they are cheap.
Item 30.
Take this.
That admission of students matter.
Students matter.
I may be part of item 30 million.
Mr. Das, just wait. That matter was mentioned. That admission.
62.
Yesterday's matter.
Yes.
Item 62, lordships.
Where is the counsel DSJ?
We had informed him.
I mean, he said, he said 2 o'clock.
Then I had informed him that we were mentioning in the morning. Then he said that he will intimate somebody because last time Mr. Gochayat had taken notice.
Yes.
Just take the words for him. You should. In the meanwhile, let him come.
Lordship,
Must he call the DSG, send the words to him. Send your somebody, you need not.
No.
Yeah.
I am making a.
No, you can go for a copy. Coffee, that's another thing.
Go for a
will not come in the way.
And Mr. Raut's matter,
Yes.
Mr. R.C. Mahanti also. Not admissions.
Start.
Item 30.
Right, not 30, 61, 62, something, no?
62
61.
My matter is 62.
There are two more matters. Other advocate also mentioned it.
The 62 is that admission that I have, visual handicap bonus.
Come on.
62 minutes. Last year admission मेरा से engineering, NIT Rourkela lordships. At page 18, Lordship's not recommended, and subsequently same institute at page 21 recommends again. But there is a time lapse of around 40 odd days and he misses out because he can't access that website.
Yes. The computer did not work.
No, system did not accept. System did accept it.
Is coming?
He will be online.
Okay. Can you give foundational facts of the case?
Whereas this student is a visually impaired person.
The extent of impairment is?
More than 40% losses. His disability certificate is at page 16. And he was issued with the I card also is at page 17. Unique disability ID. Where it records disability percentage is 42. And the ID
is 40.
40. This candidate is 2 as per the I card issued by the Union of India. And my lord,
page 17.
17 is the ID.
Yes.
And this ID,
you can hear us. Can you unmute Mr. Padi?
My lord, audible, my lord.
So regarding that allowing in the computer system, what is your instruction? You will allow?
I don't. Can Lordship pass over after lunch or after 1 meter? I can appraise the code. We are out of station. That's why I cannot. A medical issue. I am come to outside. So I can assist the code just after 10 minutes.
2 o'clock. Then 2 p.m.
Just after 10 minutes, my lord. It's sufficient. After 10 minutes.
Right. So let it be conveniently after 2 o'clock because other matters again will be passed over, has to be passed over. So please, but get a written or at least a message so that you are not put to difficulty later.
And a disabled person. How Apex Court said, how disabled person should be treated.
Yes, true.
Can you stand on the formalities? He is disabled because of the act of the God. You can't add more disability by act of man.
And we have granted sufficient time, Mr. Padi, also, because the admission matter, we have already 3 weeks have been spent. Please appreciate that.
Very good. Come, let it come. And it will be appreciated if you are present personally. Generally, ASGs and DSGs should be personally present in all courts.
My lord, I'm sorry, my lord, I'm out of session. That's why the medical issue. Kindly may accommodate, my lord. Yes.
Come by 2 p.m.
Yes, my lord. Yes, I will join you at 2 p.m. Yes.
Mr. Gochayat is here. He can come to court.
Yes. I ask anyone to be present there. Mr. Sethi in this case. But I ask a senior counsel there. I will be joining.
You join him?
Yes.
There is one UN resolution to which India is a party, which relates to visually impaired persons.
I'll find out what's
that you have to.
The Supreme Court judgment has referred to
There is a Supreme Court judgment. There is a Karnataka High Court judgment. Incidentally, I was the author. That one. There is a Tamil Nadu judgment about them. It gives a broad idea. It gives a judicial pattern how courts approach to the problems of disabled persons. Just looking.
I'll look into
Item 30.
My lord.
Your Lordship, pardon to mention, Your Lordship. In item 62, I have instructions to appear for OP3.
Correct. Since Mr. Raut is not there, Mr. Shubhankar Raut, who mentioned, it will be taken up at 2. Please be present at 2 p.m.
Read and come back.
Your Lordship.
Okay.
Item 30, you are called?
Item 30.
30. So last.
The state of Karnataka versus Lata HN.
Correct. Just look into it. We will have the general pattern of the judicial approach to the problems of man.
Definitely not.
Yes.
Item 30.
My lord, in this matter, your lordship has for the record to ascertain as to whether that the appellate authority, the order has been passed by the appellate authority and the disciplinary authority is the same because he has employed the same and one person, my lord. My contention was that. And
the same. By order of the governor.
It is by order of the governor.
What is the position?
Records you have got
the short
records, my lord. The appellate authority.
Then by virtue of promotion, he sat in the as appellate authority. He passed
confirmed that governor, they appeal to the governor. And that person has confirmed the order which has been passed by the
governor. No, this governor's power is delegated to the government. So who was minister has passed or the governor has passed, you have to produce the records.
Yes. Under the transaction of business rules, similar rules are there for the working of the governor. And in 1980 Supreme Court, Ram versus Union of India, 80 Supreme Court, perhaps 79 or 8, I don't remember the correct year. The Supreme Court said, Honorable Supreme Court said, governor means government of the state. President means union government. And it said governor is the shorthand for the state government. President is the shorthand for the central government. These are the sentences which appear in that Maruram. Can anybody take out, where is our researcher? Take out Maruram versus Union of India. No researchers in the whole bar. Yes, what's your name? Just looking.
Philosophy 1980.
80 Supreme Court.
Yes.
1980, year 1980, 2147.
Yes, 2147.
Just look at judgment. And then this. Okay. Now, final aspect, which my esteemed brother points out. If it is a doctrine of necessity, then this argument will not be available. So that aspect is treated by the Apex Court in TM Session versus Union of India. Justice Ahmadi's judgment.
And also it cannot extend to that extent that he will pass the order again.
Yes.
The last allegation is that the principal secretary or I don't remember, the additional chief secretary who passed the order has passed the order again. Your contention is that it was passed, maybe delegated by the governor or the governor. Yes. He has only communicated it.
That was to certain that we need the file. Original file you have to exhibit to us.
And you look at the order dated 14/7.
Yes, ma'am.
Finally, you have not received.
Part file I have received. This is a bulky document.
No, you verify. Can you verify by the...
You have, correct, it's difficult to understand.
Yeah, I have
your
got
friend
that.
also with you. But you, unfortunately, your friend is online. If he comes here,
it's a 1,000-page documents.
that's very hard.
Index, which is short point. They should.
Whether.
So can you do it at 2 p.m. or 4 p.m.?
No, but we'll ask him. Need some more time.
Someday, in the meanwhile, you can look in. If you come to court, all these problems will be solved. If you remain outside the court, problems will again adjournment.
Your lordship, tomorrow or beyond.
No, we are not at your disposal. Call this matter after 4 weeks. Yes. We wanted to grant relief, but if you do not assist, this will happen. Yes.
Or your lordship, after lunch, your lordship, after lunch, I will be there.
See everything. Why should not you can go to agent people come here? Yes. How will you look into the paper? How the government advocate should exhibit his papers now? Original records he has brought from the governor's office. What should we do? Again, wasting the time. Yes.
Item 30 was...
Sorted your lordship, sorted your lordship. I may pardon, my lord, your subject.
This is item 31. Last time we had let's put across regarding the regulation of that health workers in that leprosy eradication program. Again, my lords, by judgment of 7th March 2025, lordships by the Honorable Supreme Court, my lords, it has been confirmed that the same facts remains. My lords, may I read out, lordships. Last time I had given the judgment of Chittaranjan Meher, lordships. The copy was also supplied to the state. Now, let me read. Learned counsel parties have fairly stated before us that the issue as involved in the present case has been set at rest by this court in so and so, so and so. The relevant portion is extracted, lordships. Then para 2 reads, as considered before us, the present special petition may be treated as disposed of in the above terms, my lords. Chittaranjan Meher covers my matters, my lords. And last time the state was to take instruction on that point. Because
in fact, I was doing the matter, but today it has been intercepted.
Yeah.
But somehow or other, starting from the Amit Misra to Chittaranjan Meher, and subsequently, my lords, other day, asked me that question, whether the 13 persons belong to other district of Kandhamal, similarly situated persons, whether they have got the benefit or not, so far the MPHW is concerned. That I have ascertained.
To another district. Can we deny the benefit?
No, that I have ascertained. So far, these 3 judgments of Honorable Apex Court is concerned, only on the ground of delay and laches. No, it's an issue. And subsequently, in Amit Misra case, it was confirmed. And in fact, 13 persons belongs to the Kandhamal district also. They have got the
Then benefit has to be given to the
So our judgment following Amit Misra, where is that?
no, not Amit Misra, it is Chittaranjan Meher. No, he's citing Amit Misra. Same.
Let me see that now.
Since we have already pronounced that. So you are saying that Chittaranjan Meher also covers similar to Amit Misra?
In Chittaranjan Meher, the numbers which has been cited, they are all doctors, my lord. So far, the Gitanjali, the iron matters are there.
Doctors means Ayurvedic. Homeopathic doctors.
And your clients, sir?
They are health workers, lordships. They were working.
Then Amit Misra.
Exactly, man. And whereas the issue is
Multiple health workers.
Similarly placed persons in one district are absorbed, regularized.
Okay, Mr. Samantray, they are multi-purpose health worker working in NRHM.
Yes, ma'am. Not leprosy eradication. Leprosy eradication absorbed,
Project.
then regularized. And in one district, in Sundargarh, they are in total absorbed. In my case, I belong to different district, but there is no difference.
Okay, Mr. Rautra. He says that Samantray. He says that Kandhamal has been got the benefit also.
Yes, ma'am.
That he is not.
13% that I have taken the instruction.
But should we rely on this?
We should rely on both the judgments.
Both the judgments. Our judgment in Amit. What is that judgment we have rendered?
Amit Misra.
Following Amit Misra, we have rendered a judgment.
Yes.
Shavindra Kumar Samal.
Abindra Samal.
Number
WA 1323 of 2023.
WA 1323. 2023.
It was state's appeal. State's appeal dismissed.
That is pharmacist, but the
Leprosy, health worker, pharmacist, nurses, all
homeopathic doctors.
But doctors are just group B.
There may be another
category.
in rate of appeal, my lord, they have relied upon the doctor's case.
It is now date tak boon tu.
2025.
Yes, yes. 2nd July 2025.
So, upon it print card. Just so we'll get that print.
Along with that, Viren Mitra, because all the cases are, it is starting from Viren Mitra Swami.
Viren Mitra case, my lord, that is relates to the Kandhamal district. And that went to the Honorable Apex Court, and after dismissal, they have implemented by giving 14%.
Only on that score, that all other things left open so far the question of law is concerned. And keeping in view, these 13% have got the benefit. So far
then how can you deny that benefit to them?
It is my duty to apply your lordship, sir, with all fairness.
We will certify that you argued very well. But how can we discriminate on the ground that cow is on the other side of the stream? All cows constitute one bovine community.
Name of the party, state versus
Shavindra Samal.
It is pharmacist.
Shavindra Kumar Samal Balos, WA A1323.
We are not interested whether it is pharmacy children, but since we are showing in detail, so that is how that will help us.
Please, Lordships. And these two orders, matters are passed. The latest one in 25 Lordships. Chittaranjan Meher. And the precedent value which they had cited that cannot be taken present, that has also been knocked out subsequently.
That's also.
Yes, knocked out, my lord. And they concede before Supreme Court, my lords.
Because in that apex court said in one matter, right? D.P. Joshi versus State of Madhya Pradesh is what my professor used to say. Mr. Panda, can you take out that decision? D.P. Joshi versus State of Madhya Pradesh, where apex court said on geographical area, you cannot discriminate. Because 16 prohibits discrimination. On geographical discrimination is old judgment, classic judgment, which were taught in the law school.
1955, my association.
1955.
Correct, maybe. But that is reiterated even subsequently.
It's fundamental.
Yeah. Although that judgment is not referred in any of the judgments.
State of Madhya Bharat.
Madhya Bharat. Correct.
My lords, in light of that Chabindra Samal, these matters can be
matters. Yes, sir, brother, we are dismissing by following our data. We will say that you have argued the matter.
But in all these cases, it was kept open. So far, it will not be taken as a precedent as
open is all right. But now open before us. Where is that? What you can open? Apex court by abundant D.P. Joshi versus State of Madhya Bharat. 55 something.
334. It is 334.
Yeah, right.
My lords, I have handed over one page judgment of this dated 9/9/2024, my lords. Priyambada Patnaik.
Dismissed. The reasons to follow.
Please, lords. Grateful, my lords.
Item 32.
That will one big group of 2023. Take all your proposals. Sir, office and 27/2025. Why it is, no? Whether someone is printed by Sassan.
Seven 861 of 2024, that is for continuation of delay mail, and there is delay of 15 days in filing the writ appeal.
Already notice issued.
No, ma'am.
Not yet issued. Or say something on the merits.
Let the delay be condoned, madam.
No. The question is, in condoning delay, apex court has said merits of the matter is also one of the considerations.
Yes,
therefore, they are asking you to say a few words on the merits.
The matter is relating to contractual appointment of Hindi teacher under the Director of Secondary Education, Government of Orissa. And today, actually, I am not ready today, my lord.
Not after 4 weeks. At the request of arguing counsel for the we don't understand that we are not ready means you are the appellant. If you were to be respondent, we would have understood. You have we are saying few sentences to say on merits. Anyway, bus is you have missed the bus. Let's call up for 4 weeks.
Item 33.
This is the inter-court appeal, my lord.
Yes.
The Honorable Single Judge direction for regularization of the petitioners.
How many years?
Lord, he was initially appointed in the deliberated employee, my lord, in the year 95. And subsequently, my lord, he was disallowed to continue, my lord. He approached the London Tribunal, and Tribunal directed for reinstatement, my lord. He was allowed to reach April 2018, my lord, and subsequently, voluntarily, my lord, not worked for as the London Tribunal, my lord, directed. Lordship, can you glance to?
He has worked since 1995.
My lord.
And prior directed reinstatement, you complied with the order?
Yes, my lord. In 2008, he was reinstated, my lord.
Yeah. And
But
he joined on 4/7/2018 is your version.
And he subsequently, my lord, not discharged due to, my lord.
You should have but dismissed him. He has not discharged duty. There is a provision. He does not. There need not be impeachment proceeding for that.
My lord,
You could have simply issued an order. You are not doing your duty. Go home.
Thereafter, my lord, he approached this honorable court, my lord. And this honorable court
issue emergent notice. There is delay also.
My lord.
Item 35.
Issue remuneration merits.
Item 35, I'm appealing for respondent number 1, my lord.
Yes, sir.
This is with the field, your lordship, preferred by the commission. There is also an application for condonation of delay.
What say a few words on merits?
Your lordship, this and the commission is challenging the judgment of the learned single judge, where the respondent, who was a candidate who had applied, that has been issued for appointment to the post of OS officers and civil services officer, where the categorization of under the PWD category 3 has been rejected, and the court has directed that the petitioner may be considered, in light of the reasons given in the judgment, to be considered under multiple disability category. So as per the notification,
multiple facility is not available. Disability category is not there.
It's there, your lordship. It's there. It is our case.
Only for certain kinds of.
No, it is our case that as per the 2021 notification issued by the government, if you have two disabilities which has been listed out in from A to D of clause number 12, then only you can be termed as a multiple disability category. In this case, it is undisputed that petitioner has locomotor disability and hemophilia, which has been certified by the medical officer and the medical board.
No, hemophilia is another disability.
Yes, Your Lordship. Your Lordship only see the.
It's a multiple disabilities.
Lordship may only see page 112.
But you are saying that is not in the list.
Yes.
That hemophilia is not in the list.
Not in the list.
Only listed disability alone is considered.
Which is, and this categorization.
Lordship, I'm searching for something.
Lordship.
Only enlisted the so-called multiple disability should be scripted in the notification itself, any one of them. That's your case.
That is state government's notification.
This state government notification is pari-materia that has been given under 34(1) of the Central Act, which is the Right of Persons with Disabilities Act, Your Lordship. If Your Lordship may only see.
Then the next question would be, we got your point.
Lordship.
But how the court has dealt with it? How the court could include.
Your Lordship,
when it's not in the enlisted.
Your Lordship, the court has placed reliance on a notification given by the central government in 2018, where in the list of specified disabilities, there were 20 specified disabilities.
Includes hemophilia also.
Includes hemophilia.
Your contention is we are not concerned with the notification of the central government. We are concerned with the state government notification.
And which is in terms with section 34(1) of the statute, Your Lordship, which is a Central Act. Your Lordship may only see section 34.
1 second. I don't have much idea about the disability act. I mean, dealt with only few matters. Whether central government has got power to notify disabilities.
Yes, Your Lordship.
Whether the state government has got power to notify the disabilities?
No, Your Lordship.
No. It's only central government has got power.
Yes, Your Lordship. As per Section 56 of the Act, Your Lordship, central government has the power to issue guidelines for assessment of specified disabilities. They can issue guidelines for assessment of the specified disabilities. And in the schedule, the disabilities have been listed out under the central act.
Hemophilia is also one.
Hemophilia is one, Your Lordship. Here, Your Lordship, the question is mainly when the government has been recommended under category 3 and thereby he is eligible for OFS cadre. What the petitioner wants is that he should be recommended for multiple disability category so that he will get the OS cadre. Only the categorization of the petitioner under which category is the dispute or the subject matter before Your Lordship.
Consideration.
Let a copy of the appeal memo and limitation application.
Notice is ordered?
No, Your Lordship. No, delay has to be consumed, Your Lordship.
Issue notice, but give him copy.
I will serve.
Delay, short delay.
94 days, Your Lordship.
94 days.
Let it pay some cost.
The appeal is filed after booking a short for 94 days. First up, an application supported by the affidavit accompanies the appeal memo seeking its condonation. First up, delay is short and explanation offered is broadly plausible. First up, that apart, there is some arguable point in the appeal on merits. First up, next up, in the above circumstances, application is favored and delay is condoned. Subject to the condition that the appellant shall pay rupees 2,500 to the respondent candidate within 2 weeks. Employee within 2 weeks.
You have got training as OFS?
Yes, madam. I'm considered assistant.
Then why should you seek this amount of? You are in a class 1 service getting about 1 lakh.
That's to the High Court bar.
High Court bar. Give 2,000 High Court bar association.
Taken on record.
Let's get a copy of the appeal memo. Please serve on me.
I will serve, Your Lordship.
Copy and copy.
Yes, definitely.
Is it done?
Yes, Your Lordship.
My
Very
evidence
much.
may be written.
The next day will be
Concepts and the reflected from the respondents and the reflected in the coordinates and as well as case study. From the next 15 minutes.
Third, your panel counsel.
No, Your Lordship. I am the standing counsel for the commission, Your Lordship.
Standing counsel, Mr. Sahoo, so for the appellant. And learned the advocate, the Sahoo, so appeal is processed on.
Sharon Patnaik or Mr.
The next date, Your Lordship.
Yeah.
Your Lordship.
In order as played on.
Your Lordship.
Till next date of.
Your Lordship. Next date.
Contempt already filed valid. They have not got
order. Secondary order has been brought here.
But Mr. Mr. How do you get the training and all that? Because you have got benefit of reservation.
Yes.
Now because the other aspect would be, suppose the court directs him to be considered as multiple disability. How many candidates are all there? Because it becomes a judgment in rem.
The rest of the people also will
in para 7.5 of the impugned judgment, the categories it is clearly mentioned and elaborated by the honorable single judge.
That Mr. Patnaik has not disputed also. That was how it is arrived by. But now suppose we direct that yes it is, then how the learned court, because the entire merit list will go
definitely.
What fell from Lordship, I will also seek instructions as to whether any candidate has been recommended under multiple disability for OS. So therefore, then that will be a relevant fact.
Has become a given for rest of the basically what are the in view of the pendency of contempt proceedings instituted by the respondent employee.
And his interest in IFS, finance service or administrative service, perhaps they don't realize after 30 years. The finance service are getting ahead in promotion.
Yes.
At the level of additional secretary and special secretary, also in Indian administrative service. It has happened already, so that is how I am saying.
Now, in the meantime, already respondent has already cleared the ICS main exactly.
Cleared the ICS.
Yes.
So, litigating has become proven to be lucky for him. Till he clears the interview, then he will withdraw. Could be, sir.
My Lord had
the court is lucky or what?
This joining is the second joining.
So in the ICS, he has got multiple or single?
Yes, that multiple. The
central
EPC did not allow him to appear below the court. He approached the CAT bench, principal bench, by virtue of the interview.
So what is the decision of CIT?
This is still pending. Still pending.
Item 38, my Lord had permitted me to remind at 12:45 that item. Yes. And
after this matter?
Yes.
37, my lord. On merit, my lord, there was a resolution at Annexure 2. Annexure 2 resolution dated 4/9/2012, whereby all the NMR DLR employees were taken to be temporary employees, and they were given minimum pension. And this resolution was not challenged, and it has been saved by the impugned judgment, whereby the order which was impugned before the single judge, relying upon this resolution, that was set aside. But this resolution still subsists. This resolution still holds good on the premises, my lord, that all the Group D employees, NMR DLRs, have been given the temporary status and scheme for absorption of casual daily wage laborers.
Yes,
May I say something, Madam? The peon appointed in 90, after sponsored by the Employment Exchange. This honorable single is not getting pension.
Minimum pension, my lord. Minimum pension.
No, honorable single judge directed 92.
There are functions of them. But obviously, after Sudhanshu Dena,
yes, my lord.
Whether minimum pension or they was also considered.
No, he was appointed in 90.
Sudhanshu Dena has taken care of all the judgments by partner this board and all the board.
All they are enlisted, and that we have enlisted in another judgment. Therefore, matter requires flexibility.
Yes, sir.
It will fix some short date.
And if you are 30 with minimum pension.
No, not 30, but distress condition.
It is a case of antedation of regularization.
But standing is that you are unable to get minimum pension. They will also.
They will agree. We have formulated the scheme for that.
It's a case of antedation of regularization.
No, not antedation.
On the basis of Amarkant Ray's case.
Yes, minimum pension.
The scheme. Then in terms of that, we say only in 4 sentence order it will be. And he cannot challenge it because he has agreed to it.
For that, I want 1 week time.
The resolution is to be examined, Lord, 4/9/2012. That is your lord's.
Consensus. So yes, not the respondent. How many employees?
Only one.
First. You operate for anything order?
Yes, ma'am.
Next day,
After filing of contempt, they have filed the writ.
Yes.
Since Democrats were in the Parliament of violence, I'm going to proceed. It's very right.
Your lordship fix it.
First week of September?
Yes, ma'am.
Intimate only till then.
My lord.
No final.
No, my lord.
Yes.
Item 51. Sorry, I had to break the line, my lord. I have.
You said that you wanted.
Yes. My
Yeah.
lord, I am. Yes. Item 65. That regarding the counseling for those nursing college students, Nalanda and two institutes, we have complied, my lords, your lordship's last direction. We have extended the date for counseling by 4 days. And whatever else, my lords, order, I'll pass on our extended schedule. 65. Just specially fixed at 2 p.m.
This is not toxic.
Not nursing, the inspection matter of that is engineering college and management. 65.
Yes, I have completed and one.
My only submission is this. Just lordship, pardon me, manners. Just only submission. Whatever other orders your lordship passes today, manners, we'll implement. We are only the implementing agency for OJE. Our officer has also come. He's there, secretary's office. Lordship, excuse me.
And the schedule is fine.
We have scheduled it to 28th, 4 days, your lordship. It was here, we have extended by 4 days.
That was your play.
No, that was the direction of your lordships.
No, that's not that. That is not play. Then in furtherance of that, what should be done?
Yes.
What he said the inspection.
Lord, kindly having
increasing seat.
No. One college Lord we have already recommended. So far as 14194425.
It has become infectious.
Yes, it is right.
Yes. So, Bali, only one. So, since you have already said that you will explain.
We will upload.
Recommendation will be carried out.
With regard to this college, recommendation will be carried out.
That's having become infectious. Why is this season?
Trident.
Yes, ma'am. Yes.
Trident states will be reflected, right? I'll just inform. Trident. Since Trident has been done, we'll upload it. Rest of it, your lordship may hear the other one.
My lord, what that is on the petition.
No, no. I'm sorry, madam. I'm sorry. Lordship Justice, Honorable Justice Sahoo.
Lordship, find the yes, find the report. They have increased their the professor and the lecturer.
One second. That's the one matter. Two matters, sir.
Two matters.
One matter what I have just now handed over. Not that we have considered and recommended as recommendation.
So that petition has become government and position appealing from the respondent university.
Yes, sir.
Respondent university and file is removed, dated 25/7/2025. Accompanied by the report of inspection E.
What joint inspection report by AICT and the.
No, that
was the direction.
Report of inspection. Dated 24/7/2025. Right. Perfect. The memo of DIXIT as under the final inspection report is by the committee comprising of DPUT nominee, three DPUT nominees and one AICT nominees. They will not take this. Next paragraph. Further, the panel council submits that in view of recommendation of the committee as mentioned in the subject report, the further action in favor of the petitioner's institution has been followed, and thus the petition has become infructuous. First one. Learned panel council, senior council representing the Orissa Joint Entrance Examination Committee submits that they have rescheduled the admission process, the counseling process in terms of our interim order dated 22/7/2025. First, in the above circumstances, the petition has become infructuous and is accordingly disposed.
Where made in the petition. Well, so far the other college is concerned, Miller, that Nalanda. I have not got the report, Miller.
You get that?
Just now.
Share the copy of.
Yes, sir, just now.
Miller.
Share with us also.
Yes,
Miller.
And
Give me just only 2 days. Monday, 2 p.m. So that we can get a chance to withstand it, Miller.
Tuesday, Miller.
Tuesday at 2 p.m. Your lords may kindly fix up because.
So, the party will be taken up on Monday, the rescheduled counseling.
They will be affected.
Will be affected on Monday.
It is up to fast, Miller. It is up to fast, Miller.
In the event,
Monday go to
this is the last date is Monday, 28th. 28th is the last. It will start.
Okay.
We'll start or from 28th till 1st of August, it will continue.
We should argue this finally and
Miller 28.
unless you challenge this order, you have rejected. Yes, yes, but they have not been in the consonance with the AICT norms. No faculties there and faculty details I have given. So, proper is gone. This case, it's AICT recommended.
Miller.
They have to recommend.
Miller.
For that reason, this order was not that let AICT jointly inspect along with them.
Miller faculty, I will show the proposition of law as well as
now, Mr. Das, there's so many category of decisions that whether High Court can replace AICT and PQT and UGD what said.
The decisions are there, Miller. Apart from that, as per my conception, Miller, as per my understanding, out of my experience, Miller, the first year course is always same, Miller. In the
One part that you have to overcome the AICT observing that you are not satisfied. So your repetition is entirely under premises that AICT has recommended.
AICT has given me the approval for the presentation.
Correct, sir.
Now
that is how AICT came into picture. Otherwise, PPUT could have objected. That it is in our domain to examine or supervise.
That is the question of law, Miller.
Listen, sir, if not. Because you see,
another aspect is there, Miller. So far, the guidelines is concerned, BPUT.
Mr. Post will not be indulgent to extend any further modification because that will spoil the whole thing. As far as rescheduling of OJ is concerned.
Admission is open up to 15 million.
Lakshmi, excuse my presence.
Yes, please. Yes. Rather, you told us, but we retained it. Mr. Mishra is there.
Your Lordship, may kindly fix up it on Monday, so that I will try to my best of my ability to satisfy your Lordship because the as per the BPUT own procedure, the first year course is same, Miller.
2 o'clock. Monday 2 o'clock.
65 seat.
65. Item 65.
Second matter.
First item disposed of. Second item
18294.
18294. The report has been furnished by the Learned Council, the Learned Panel Council, Mr. Standing Council. Panel Council, Mr. Satpathy, dated 25/7/2025. Imposing report on inspection team visit to the Petitioner Institute on 24/7/2025 at 9 a.m. The members were nominees of BPUT into bracket 3 and AICTE. The report also encloses the staff identification report dated 24/7/2025, furnished by the principal of the Petitioner Institute. In the calculation, as well as the calculation as per the AICT, marked as annexure. As per AICT, SFRs, staffing patterns.
Student faculty ratio.
Sorry, sir. Student faculty ratio. As for the AICTE student faculty ratio, 1:20. The memo is the memo along with the report and enclosures is taken on record as prayed for by the Learned Council for the petitioner. Mr. Monday, liberty to mention.
Copy was just now served on me, Miller. Copy of
Therefore, we can't. You said Monday, na?
Yes, Miller.
Lordship, may I request another item 60. This BPUT matter. Your Lordship, I will take instructions so far as the certificate is concerned. Lord, I may take Monday because I am also requested my predecessor because I am not able to get the instruction properly. Monday.
Post on Monday at the request of the panel council, Mr.
Must BB Mishra for the petitioner.
Yes, my lord. That is with regard to declaration of results, my lord.
Monday.
Yes, I will.
I have heard the OP3.
My appearance for OP for the matters item 65 minutes.
Because Jena for AICT.
I am for the open number 1.
Mr. Devraj Mohanty, AGA for OP.
Item 33.
Item 62 was on the petrol.
Yes. The student.
Lordship, item 62. I'm filing the wakalatnama for NIT, Your Lordship, OP number 3.
Okay. Who is the answering respondent?
Your Lordship, I have to present one fact which has been suppressed in this description.
Just give that.
Vidhat Sahoo.
Your Lordship.
Vidhat Sahoo appears on behalf of the opposing party. 3.
Your Lordship.
we Registrar NIT Rourkela files Wakalatnama, which is taken on record. You are filing affidavit.
Affidavit I have not filed, Your Lordship. Only today I have got the Wakalatnama.
Memo yourself. What is it?
Your Lordship, one fact has been suppressed, and if Your Lordship puts the matter, I will file the affidavit, necessary affidavit, Your Lordship.
No problem.
Your Lordship, what happened in this case, and earlier writ petition was filed, and it was with the same prayer, same documents were annexed, and it was dismissed, Your Lordship. That fact has not been brought on record in this writ petition.
On Monday, but this you have to state in your pleadings.
Your Lordship.
Cannot be an oral submission.
Your Lordship, I'll file affidavit.
135025.
Your Lordship. That is a wrong date, Your Lordship. It has been dismissed on 19/3/2025.
The date is different.
So date is the legal mistake.
Where is the
submission in declaration?
Your Lordship.
So once it is declared, that is enough. Yes.
Your Lordship, the writ petition has been dismissed on merits, and I'll file an affidavit. I'll file an affidavit on Monday.
Monday we will have this.
Your Lordship.
But beyond Monday, don't ask again.
Your Lordship.
Finally, call this matter on Monday.
The whole purpose is that if they are entitled for admission, they should get.
Fine, Your Lordship.
Or counseling, like the other matter, counseling should be, because rescheduling the whole thing is not possible.
Your Lordship, on Monday I'll file.
Monday.
Your Lordship.
Monday. Finally, at the request of the panel counsel appearing for.
Panel counsel, Your Lordship, I am not the panel counsel. I am appearing on behalf of M.S.Sahoo, who is the panel counsel.
M.S.Sahoo.
Well, it's in item 31, Lordship, the lead matter I mentioned that batch matter, Lordships. Which matters? The item 31 which we had argued for lunch, Lordships.
31?
Yeah. I have given the number of the lead matter, my Lord, Gajendra Pali. The pleadings are all complete, including the writ petition, my Lord. The small indulgence, Lordships. I am providing the number.
Yes. Same time,
Grateful, Lordships. Okay.
DSCI, any instruction in that item 62?
63 and 64.
61, Your Lordship. 61.
61, 63, 65. 64.
64 minutes.
61.
61 minutes.
61. So everything is ready, affidavit, everything is ready.
DSCI is not. So Monday we will have this. Now finally, call this matter on Monday at the request of learned legal GIs. Finally. Yeah.
My Lord, 63, in first item, he has not applied for renewal. I have got the instruction. Because those for renewal applications which has not been filed.
Fair enough, Mr. Manti, 63 which for the petitioner? Sir, you have not applied?
Applied, my Lord. Where is that?
Applied because so actually these things should not come to the
show to him.
Applied or not applied, who is then?
No problem is that.
At least show him, sir. Because his responsibility is that he has taken instruction. With some responsibility is saying this.
My Lord, I have got the instruction also.
Manti, then if he applies now, is it anything possible?
No.
Cut-off date is over.
My Lord, that time also, that day he requested that because the money he has already deposited, why not that should be refunded? So I asked them, I found those for renewal, no, those cases are pending, they have not applied. No money has been received.
No money is paid.
No. The other cases which are posted, no one has deposited the money. He has deposited money on 25th of February, whereas our last date of submission of application was 15th of January. So I got this instruction that he has not met because I told this was the Honorable Court observation that why the money should be kept if he has not applied. So I have got to, even if we are ready to return back the money.
But that money he will refund.
Yes,
with that money, can you not reconsider if he has applied?
No, my Lord, he has not applied.
Sorry, wherever anyone has applied.
No one has applied.
No one has applied.
No, for the renewal, there are on 14th some cases are posted where they have not applied because they have given us the application, their cases to be considered.
Can they meet your authority with the credential which they show that
these are applicable applications?
No. This is the instruction I have got.
Because we cannot adjudicate there.
My Lord.
So suppose they go to your authority and show that the receipt or whatever acknowledgement that we have applied. Then can you consider? I don't say reconsider.
No,
we don't say reconsider.
We cannot consider because the application is there and the cut-off date is over. Because same similar matters.
Just prima facie show us where is your application.
My lord, I have applied through online, my lord. Both this normally.
Where is the application?
Yes, ma'am. They have received it, my lord.
Show it. Where is your application?
Application the staff was dealing all the matters.
You chase the staff only then.
Sir, the staff leaving and the website has not left you.
You should have applied online. They would have considered. And the last date was 15th January.
Yes, ma'am.
You applied, if at all you have applied, on 25 February.
Deposited money.
Only you deposited money. But application has to be accompanied by the cash deposit.
Liberty went to.
No, it cannot be. Apex Court said, where application prescribes the fees, rules prescribe the fee, your application without payment of fee is no application.
Already I have applied and
no, it makes no sense. You are making us to repeat the things.
Oh my.
It does not make sense saying that the staff who has applied has left you. How can we ask them that? When you are not, you have applied not saying anything.
My lord,
your answer is the staff has left. So what they will do?
After the staff was left, we met them and applied for the renewal. My lord, they received the application. My lord,
the staff had applied in the website or not, online or not.
It has to be on online.
It has to be online. The staff leaving you,
it makes no difference.
The staff doesn't make any difference also. Online application remains online.
Like there is nothing. But that money you cannot retain.
No, that is instruction is where you will pay the money.
You will pay back the money too.
Yes, madam. That is what my instruction.
So in this case, WPC 16087, can you hand over the instruction? Or common instruction you are having?
So second one.
I
am common instruction I have got, not this case.
Fair enough.
But anyway, he has to show. Yes. Prima facie, he has to satisfy that he has applied. Yes. That satisfaction is falling short of requirement.
Maybe placed me on 14th date, along with other matters.
Now, if you have not produced any material to vouch that you had applied, number one,
I have.
Yes, ma'am. It is no application because you did not remit the money along with the application.
Well, let me the matter will list on 14th date.
All this matter after 2 weeks.
Similar matter, along with similar matters, posted to 14th.
14th August. Okay. Along with other connected matters. Do you have one matter?
No.
You are only postponing.
No.
14th is the voting date. In the meanwhile, file a short objection because your instructions will not be sufficient.
No.
File affidavit saying that they have not applied.
No. Yes, my lord. No. I have got the instruction.
That is immaterial. That is between you and your client.
I will get an affidavit.
My matter is different. Sub-item.
All on 14th.
No, my lord. These matters, my lord wanted. I have got the instruction. I have got the instruction over telephone. I told them they have given me instruction by mail. That they will consider their cases on such and such conditions.
So then,
I have shown them a copy.
Give that copy. At least they will be happy with that. Have you put up any condition which is impossible?
Or we can make photocopy. If you do not have to make it and hand it them over.
Just give and show it to your friend also.
I have given them. Given to government council also. I have given.
Yes.
This is common in all or?
No, there are 2-3 cases are there which are different. Otherwise, all the cases will cover with this.
Some of my cases are also covered by this.
My case is the next first case.
That I will mention, my lord, what the cases I will tell one by one so that will be disposed.
What should be the nature of order?
My lord.
What we should say in our order?
Instead of the previous order, my lord.
Can you dispose of this recording? Yes, sir.
Yes, Miller.
WPC 16200.
My matter, man.
So you are satisfied with this, Mr. Mohanty?
Yes, madam.
I am.
More importantly, you have to say that yes, it is
yes,
because you don't mention any repetition number.
I have, my lord, I have completed all the.
Should we call our writ application number for your lordship?
No, not necessary.
Yes, ma'am.
6815?
Your
Yes.
lordship.
Subhankar?
Yes, your lordship.
Yes, madam. Then Mr. Das, your is.
Yes, this one is covered, my lord.
In 60.
The essential grievance of the petitioner institutions is as to non-consideration of the request for the issuance of new NOC 25-26 for the academic year 2025-26.
Your lordship.
Next paragraph. After service of notice, the answering respondent, which is that?
DMT.
DMT and
Note 213.
213. DMT and ONMRC.
Register.
Respondent, the answering respondent
ONMRC. ONMRC.
Register.
Has filed, having entered appearance through its panel counsel, has filed a memo dated 25/7/2025, which has issued by the Director of Medical Education and Training, Odisha, which reads as under. First up. Next paragraph. The memo was confronted to learned advocates appearing for the institutions, and they agree that in terms of the assurance given in the memo, their petition can be disposed of. First, in the above circumstances, all these petitions are disposed of. Within what period you will do that?
3 weeks minimum.
First time.
Can it be?
The assurance.
Can it be 10 days? Because the counseling is going on.
Other things are happening.
Counseling will be going on.
September. The assurance given in the memo shall be discharged period of 10 days. Reckoned from this day.
Actually, you reply more staff.
Yes. Okay, but what's happened to the institution?
Because again, this also have to produce that.
They produce that. The structure, linguistic structure may undergo little change. But this will be the type of.
And some other cases are there.
Other cases can be disposed of.
We give that.
In 64 Miller.
Then my lord, item number 17117.
I can't read.
16.
17117 of 2025.
1 second. WP number.
Yes.
You give me. Take down.
17117 of 2025. Item 64. No, it's item number. Upon list mark karo. Upon mark karo. Dispose of. Then my lord 17917 next one. Yes, next one. Then my lord 17919. Then my lord 18164. So that's
yes.
Okay. So now your matter. Yes. Your lordship. My lord, then there is one of 18601 is not there, but this is the case. Same order. Yes. Same order. Yes.
Yeah, apart from that one matter, I made a mention in the first half when my matter was.
1 second. Let him complete the list.
So, my lord, that has been done. Or there is another case is there, which is not similar to this case.
It's a bit different.
Yes, my lord.
So other matters, Nityananda is 16814.
Yeah, that is that. We have given that. Covered.
Nityananda covered.
331983.
Sriram is covered.
No, your lord.
No,
Counter affidavit has been filed yesterday. I have been served.
WPC 3319 is of 2024. Item 64, so item 1. As stated by the Honorable Counsel for the parties, the matter to be matter to be detacked and listed independently. How much time? 1 week after?
Your lordship, 1 week.
1 week after. Liberty to mention.
Covered.
Then item 65 all covered.
65
First one, Lordship has dictated the.
Two has been paid to that engineering matter.
65 is engineering matter. 64 is ours.
Well, another nursing matter is there. I made a prayer item number 21. I have brought it to the notice of my Lord and Senior friend. 21 can be covered.
I have not gone through that.
Hey, observation jaw very. It can be disposed of with the same observation, Miller.
Mr. Das has a point because the instruction is that you will reinspect.
Yes,
can you discriminate?
No. Therefore, that also. It will dispose of that.
Miller 21 Miller.
So on your GNM.
Pioneer Miller, obliged Miller, Pioneer.
That is GNM goods.
The Manoj item 21. Same order what Milo dictated.
The 61, I will give the number of 24, which will come on 14th. I will give the number.
Disposed of.
61 no euros. 61 has been 61 has been placed on Monday. It has been adjourned to Monday.
Tuesday.
Your Lordship, the approval process would be concluded in the month of August, Your Lordship. So thereafter, I need time for admission also.
One day. Instead of Monday, because we have question. Yes,
Many matters were today also some matters are again going to after being partly disposed of.
Chandrakala.
Disposed of Chandrakala is disposed.
Chandrakala.
Yes,
Any doubt is that no difficult. Don't hesitate.
mistakes.
64 shall I repeat? Nityananda disposed of. Sriram goes out of the list. Sarasri disposed of. DN Medical disposed of. DN Medical disposed of. Yes, all are else are disposed.
Yes.
Item 33.
No, it is.
Appeal for restoration of matrimonial appeal 2051 of 2023. Well, that was dismissed due to filing of the requisites. My lord, kindly see the page 8 of the.
What is the explanation you offered?
My lord, requisites for issuance of notice and respondent not having been filed during the stipulated period, the MAT stands dismissed pursuant to the court's order number 5, state 12 to 2024.
They never appeared.
No, my
the first order is 17/8/23.
My lord. They never appeared, my lord.
None had appeared.
Appeared. My lord, the appellant is staying outside at Andaman Nicobar.
You have deposited 10 lakhs.
No, my lord, I will deposit.
You are not reading the brief, sir, Mr.
My lord, initially
we perceive something, then we find something.
My lord,
Make the payment.
This doesn't help, sir.
Initially, the 10 lakhs was added.
Finance, sir, courts are not initial and final. Sir, it has to be some particulars, some case, some material.
My lord, the earlier conducting council has not informed about the order. And
Doesn't matter, sir.
Because
Now, you see, with change of bench and with passage of time, if you hear of and go anywhere,
my lord, that is modified to 6 lakhs. I have already
at least part of the bench is here. So every day I will pass a different order.
My lord, I have already paid 2,43,000.
No.
And the rest amount has to be paid.
Rather, this is a conservative order than what we are sitting passing now.
No, my lord,
when the husband defers to pay and court takes both the courts for right, appellate court as well as the original decree court passing the decree.
My lord, he will be ready to pay, my lord, on net
He will pay that 10 lakhs now. 10 lakhs plus when it was made, order
my
was
lord,
made.
10 lakhs was modified to 6 lakhs. My lord.
All right.
My lord, I will
6
pay.
lakhs with effect from 1/9/2023.
My lord.
How much interest? 12% interest.
My lord.
All right. You bring that money. Where have you brought that money now?
My lord, within 15 days, my lord.
Learned counsel for the appellant husband submits that he is inclined to remit a sum of rupees 6 lakh.
My lord, in 6 lakhs, I have already paid 2,43,000.
When did you pay that?
My lord, that is
Sir, date.
When did you pay?
My lord.
Say the date, that's the problem. We are wasting time like this.
My lord.
You have such a bad case. For the last 2 years, you are not paying. Neither honoring the decree. Is there execution?
24/6/2023.
6 is before that order.
No, this order is
1/9/2020. 1/9/2023 is 14 lakh. Is 10.
My lord.
Sorry, 10 lakhs.
When it modified?
Sir, it is modified after order number 3.
18/12/23. If 6 lakhs plus 12%, how many months now?
In paragraph 2, the court makes clear that it is akin to a money decree. Therefore, coordinate bench required depositor for admission of the appeal.
You deposit 8 lakhs. 8 lakhs.
My 8 lakh 1 month time.
Huh?
1 month time, man.
1 month time for making this. We have not made any payment right from the beginning. 24/6/23, 1/9/23, then 18/22/23.
Then 12/2/24. The last order is actually after this 3 modification. 12/2 says that without reference to bench to be dismissed.
My lord,
Now you are saying requisites not filed.
my lord, the earlier conducting council has not informed him.
Sir, conducting counsel or not conducting counsel. So when the date is handed over to you, he should have handed you over the 10 lakhs check. Or sorry, the draft.
At least 6 lakhs at least.
6 lakhs at least.
Modification.
6 lakhs.
We have
Not done.
recently.
Anyway, within 2 weeks, will you make the payment?
My lord.
Then we will consider your request for restoration of the matter. Not otherwise.
1 month.
Why?
3 weeks, man.
The application is moved seeking restoration of the appeal to the board, the said appeal having been peremptorily dismissed for non-compliance of the order dated 1/9/2023 as modified by the order dated 18/12/23, whereunder the appellant was liable to deposit a sum of rupees 6 lakh within the prescribed period. First off, next paragraph. Learned counsel for the appellant on instructions of his client submits that he would deposit a sum of rupees 8 lakh within 4 weeks reckoned from this date as a precondition for considering the subject application. First off, the offer appears to be fair, although bona fide is in question. First off, in the above circumstances, call this matter on 2nd of September. 2nd of September. But time is 4 weeks, 3 weeks.
My lord. In the shape of the bank draft, my lord.
Huh?
In the shape of bank draft.
Yeah, in the name of the registry.
My lord.
Okay. In the registry of this one. The deposit rupees 8 lakh in the registry of the. Okay.
Item 42.
They will not bring the VPR. Yes.
The prayer of the petitioner in this writ application is for issuance of a mandamus directing the authority to consider the case of the petitioner for promotion to the post of senior clerk, my lord. The second prayer is that to allow him to continue in the Balasore Judgeship. And now the petition is
Judgeship of Balasore, that will continue.
there were components.
Was it transferred to any other?
Yes, he was transferred. That transfer order was stayed. Thereafter, that stay was vacated, but thereafter he has been adjusted in Balasore Judgeship. The main prayer is to denial of promotion. Let the petitioner
has been made.
They say that disciplinary proceeding was pending. But that is not correct, my lord.
No disciplinary proceeding was pending.
No, my lord. Just I am permitted to place some facts.
The lordship also called for the original file and original file with me. That regarding DP.
DP is there?
Yes. Punishment also imposed.
Punishment is also imposed.
One.
Yes. Have you shown it to him?
Yes, I have.
Yes, my lord. Punishment has been imposed, my lord. But that proceeding, my lord, may kindly turn to Annexure 5, that is the promotion. Page 34, page 34.
They could not get you, sir.
Punishment
because of prior to punishment or after punishment?
But
it was recalled.
They are promotion. Promotion of others.
Let me
Yes, that's good.
And my position was at the serial 71 of the gradation list.
So let us see the punishment order.
Punishment order is not annexed here. But he has been granted one increment without cumulative effect.
With cumulative.
With cumulative.
With.
Without cumulative. So that copy is not with me.
That copy you should obtain from them. How can court give you a copy of that?
But this is...
If you are punished, then of consideration.
No, my lord. Additional affidavit, my lord, page 57. Additional affidavit dated 6/4/24.
Then let me make my submission part, my lord.
Yes. No, this is the only case, sir.
No, my lord, promotion order is dated 17th May 2011. By that date, no adverse entry was communicated to the petitioner. No charge sheet was communicated to the petitioner. Thereafter, he filed charge memo was issued to the petitioner 2nd August 2011. But it is purported to have been signed on 17th May.
It is 17 May 2011.
17 May 2011.
Charge sheet.
He has been served.
Yes.
No, normally it was served on...
He was absent. Thereafter, my lord, it was served. And he has participated in the disciplinary proceeding.
Past date of DP.
First date of the DP was.
The text would say when a charge memo is given, on that date,
he went on leave from 20th. It was to be served to the presiding officer.
How it was taken to the place of petitioner?
Through Miller's special messengers and...
where is that? Which messenger?
Can you give the DP file?
Yes.
One thing you can do, you can prepare an index consulting them.
Okay.
date of proceeding, date of appearance, date of deposition.
Just look at the reverse. ସେ ଲେଖା ହେଇଥିବ ଧର୍ମାବତାର ତରଫ କରି ଜଣାଇଲେ।
Then say personal service is
notices.
Personal service, and there was no personal service. Special messenger.
Correct, sir. But participated in the proceeding.
Yes, my lord. I participated, but
so the date of issue is the date of initiation of proceeding.
My lord, they have admitted it was issued on 2/8/2011.
But that part has been suppressed in the writ petition. They are not given.
You are saying that you do not have it.
My lord, after the notice in the writ petition was issued, thereafter they served the copy of the charge on 2/8/2011. 3 months after the making of the charge.
So many things to solve. So many people. But
my lord,
how does it improve?
My lord, I have one simple prayer, my lord.
Suppose, let us assume that.
Yes, my lord.
Let us assume that you are not aware, but after you have participated and suffered the punishment, and
yes,
you are not telling the punishment, maybe after you are exonerated in the punishment, then you can say that was the only ground I was denied promotion.
Yes, my lord. They have not kept it. They have not kept it in sealed cover. The framing up the question of framing up charge came into picture after notice in the writ application was issued on them. Thereafter, the charge was served.
I am with my original file or not?
No, that's all right. Which messenger carried this mail to him?
I'll give a detail.
They say the special messenger refusal of leave.
We have asked him to indicate that.
Yes, man.
Suppose if he indicates, and that is wrong, then there is.
Like the additional affidavit, they have admitted. Paragraph 5, that on 17/5/2000, the opposite partner to come disciplinary authority had initiated a departmental proceeding by DP number 2 of 2011 against the petitioner for his misconduct, mischief and dereliction in duties and on imputation of having obtained a college to compromise the so and so on the allegation. That on 11,
para 6 of that.
it was served on 2/8/2011. They have admitted it. Paragraph 7.
On 1/8/2011, the opposite partner received a letter to the London Civil Judge Senior Division Jaleswar, white letter number such and such, to cause personal service charges upon the petitioner and return to SR of charge to the opposite partner.
No, when you initiated the proceedings, Apex Court says proceedings are initiated when the charge memo is served.
17/5 17/5 charge sheet was issued.
When? You said that in affidavit you have said 2/8.
Yes.
He has read that sentence, no?
Yes, but it is there affidavit, my lord. Paragraph 7. Paragraph 7. Additional affidavit. My lord, promotion order was.
You have said that. What is there?
Lordship, paragraph 4.
She will repeat that.
Lordship, paragraph 4. That on additional affidavit, that on 16/5/11, the opposite partner 3 had placed an allegation against the petitioner for approval to initiate the suitable disciplinary actions on the imputation of having obtained a collusive compromise decree in favor on 10/2/2010 in CS number 276 and 2010, fraudulently posing himself as a plaintiff in civil court. Plaintiff in the above civil suit during the period of his incubacy as junior clerk within bracket suit clerk in Court of Learned Civil Judge Junior Division Baleswar, and the opponent partner 2 being a disciplinary authority had approved to start the disciplinary proceeding against the petitioners. It's a Bhutan land. Bhutan land cannot be without approval of the
judge.
For that only one increment for obtaining a decree.
One increment. Yes. Major
that charge has not been established. That he has been given from that charge.
That charge is not
established. That page 59, that is the punishment.
No, punishment what? How many charges were framed or which charges were framed?
Charges, that is
7 charges were framed.
7 charges.
5 not found guilty and 2.
Which are the 2 charges which have been held proved?
That is
charge 6 and 7.
What is 6 and what is 7?
6 is the During 6, incumbency in the said you are intentionally caused delay in progressing number of suits as per the list enclosed by the annexes 2 at the instance of parties with the dishonest motive to earn in unfair way.
Next one.
And whereas during your incumbency, the suit clerk in the said court, you are intentionally caused inordinate delay in disposal of compromise and withdrawal petitions in respect of following cases, thereby harass the parties with view to extract illegal gratifications.
Both these are proved.
Yes.
That's the other way.
Yes, my lord.
So you win this case with petition.
My lord.
You win this with petition. That's a query to you.
Yes, my lord.
Seal cover is open. What would happen?
It is not.
Because you see, your best case. Your best case is that he is, despite whatever has happened, he has been given promotion and kept in shield cover. So now the shield cover is open.
Yes, my lord.
So what?
No,
your relatives say you are punished. So
no,
that I was telling
no, my lord, but my case has not been considered. The promotion file will indicate whether the departmental proceeding was pending on that day.
You are so well read.
Yes.
You find out a single decision where there is that the clock can be set back.
No, that is not possible.
So you see, the Janaki Raman is actually against the employee also, because only the right for consideration to be promoted.
Yes, my lord.
Suppose they consider and give you promotion and keep it in seal cover.
Yes, my lord.
That will not arise because
that will not arise because you are punished.
But how long you will postpone promotion?
I think he has got subsequent promotion.
Subsequently, you have been promoted.
No, from 2011 to 2024, he has not been promoted.
24, he has been granted promotion.
That I do not know correctly, but till the last date of hearing, he was not given promotion.
You have to be very pointed also. You have to say that subsequent how many DPCs you have not been considered or you have been considered and rejected.
I have filed an affidavit, my lord.
That you have to challenge. Because the ground of challenge after this punishment is over.
Yes, ma'am.
The cloud of punishment is over, you are still again considered. And what are the reasons for not giving you promotion? That you have to challenge.
But that he was never called to the DPC. During all these promotions after 2011, he was never called to the DPC.
That should have been the challenge.
That should be the
He
challenge.
ought to have been called to the DPC.
You are challenging that.
He has mistake. He has not done that. But my prayer is that on the promotion which was given in 2011, whether any proceeding on the date of promotion was pending against him.
For a person of this character, we do not agree with your submission.
He may be.
We don't. How he could be retained in the service, let alone promotion. What is the allegation against you? Such a grave allegation. 2 allegations are held proved, and the punishment is so frugal.
Only
this highly disproportionate to the gravity.
Only, my lord, causing a delay in progress of
case is required. Right to speedy justice is a fundamental right.
Yes,
you
my
have
lord.
cut short that
But,
fundamental
my lord,
right.
how bench clerk will be responsible?
We don't know. It has been held. So
If you ask these questions, we have to ask them.
No, my lord, was just like
maybe to you.
No, I didn't put it in the proper way. I failed to put that.
Sir, don't ask. You have to make out a policy.
Anyway,
yes,
man. Been proved. It may be wrong. It has been held proved, and we are happy with that.
Yes, my head.
How can we dig the grave now? It may be a wrong order, but wrong order nevertheless is effective.
No, my lord, as regards
I don't know why you have to challenge the subsequent non-consideration. This challenge is first consideration, which they should have considered and kept in seal cover. We allow your prayer to keep it in seal cover. And opening up seal cover, your promotion finished.
Very
my lord, when the bill came to me, it was too late, so I could not.
There is nothing.
After repeated inquiry, he told me.
Mr. Das, one suggestion.
Yes, man.
But not compulsory.
Yes, man.
If you observe something, if you do not withdraw after seeing the records, That may not help you for your sub.
My lord, well, I will take appropriate step, but before that, I will just.
If you want any observations from us, we don't hesitate to observe any. But one must realize that after we see the records, now we will furnish the dates, like your incidents of this. Suppose we say that yes, you have been furnished and that remains unchallenged.
Yes, my lord.
So there is no scope of giving you promotion in that decision.
Yes, my lord.
Does it help you? That call you have to take. That we cannot.
And our judgment will enter your CV. Your service register, it will enter.
I just took, your lordship will pass appropriate order.
No, not
Only I may pray that the promotion file may kindly be perused.
Mr. Das, we do not seek your advice on that. We seek your, you should reflect on what will be the consequence, because you say that you have not been subsequently considered,
yes,
and you have not been given promotion, and you have not challenged.
Yes, I have not challenged.
And this punishment you have not challenged.
No, not challenge.
So that you must consider.
Well, let it come and the next week I'll decide. I'll think about the examine and thereafter some.
At least observe this much, that pursuant to our order dated 10/7/2025 or 87. Any direction or?
Call for the record.
Earlier direction.
That is 9/12/14.
Pursuant to the order dated 9/12/2014.
14.
Nothing remains.
What for? We will pass the order. We have heard you sufficiently. We also know little service jurisprudence. May not be as much as you know. Fundamentals we know.
My only submission would be to peruse the promotion file. Therefore, the lordship may pass appropriate order.
Yes.
I am
Dismissed. We judge so far.
okay.
My lord, in second sub item, I am for a respondent husband matter. I pray for husband.
Which year matter?
2023.
You are for husband or wife?
Husband.
Husband. Any
challenging the appointment of a person who is ineligible and holding the post.
warrant.
And he is not, the Lord Council appearing for respondent for not appearing.
We'll only say next week. Next week, if there is question.